Welcome back to the Constitutional Clarion. I get asked a number of questions by my viewers about matters concerning the voice, so I'm going to deal with 3 of them quickly here because people are apparently interested, which is good. Okay, the first one is about disadvantage, and the point here is that, well, why would you put the voice permanently in the Constitution if it's intended to deal with disadvantage, given that disadvantage will hopefully disappear at one point? Okay, it's a good question. So the observation to make here is that while most of the debate about the voice and its usefulness has focused on disadvantage, it's not the only reason for it to be there. Let's go back to the opening words of the proposed amendment. It recognises Aboriginal and Torres Strait Islander peoples as the first peoples of Australia. So one reason for keeping the amendment in there is for that recognition. But the second is that Aboriginal and Torres Strait Islander peoples will always be the first peoples of Australia, even if we get to that happy day where all disadvantage has passed away. And because they are the first peoples of Australia, they will have special rights and interests which nobody else has. So, for example, ongoing native title rights to land and waters that have existed since prior to British colonisation of Australia, and also have a really important interest in Australia's cultural history that again extends back before British colonisation. So for those reasons, there will still need to be a voice that can make representations to Parliament and government about those sorts of things, where we do have laws or policies concerning native title and how it operates, or protection of cultural heritage. Now, it may well be that the voice is wound back in terms of the resources it has, how often it sits or considers things, the types of representations it makes. It may well be in the future that they are diminished, but there will always be a need for it because Aboriginal and Torres Strait Islander peoples will always be the first peoples of Australia. So I hope that answers that question for you. Now, the next question, which again was asked by a viewer, is, well, why are we keeping the race power in the Constitution? Why isn't that being amended or removed? Now, the race power, as you may remember, in section 51(26) of the Constitution, gives the Commonwealth Parliament power to make laws with respect to the people of any race for whom it's deemed necessary to make special laws. Now, there was an earlier expert panel established by Julia Gillard when she was Prime Minister that made recommendations to her in 2012. And one of its recommendations was the repeal of the race power, but there would still be a need to make laws about things like native title, cultural heritage, etc. So it proposed inserting a new power, a section 51(a), which would be a power for the Parliament to legislate with respect to Aboriginal and Torres Strait Islander peoples. Now, those proposals were later dropped as a consequence of the dialogues with Indigenous people around Australia, which led up to the Uluru Statement from the Heart. One of the reasons they were dropped appears to be that Indigenous Australians feel that 1967 referendum, which expanded the race power so that laws could be made about Aboriginal and Torres Strait Islander peoples, that referendum was an iconic moment for them. And there was a concern that it would be a sort of a form of disrespect for their elders who had fought so hard for that change to then just go and repeal that particular provision. So that's one reason anyway why that proposal was dropped and we're just going ahead with the idea of a voice to Parliament. For my money, however, I really don't like the race power in the Constitution. I don't think race is an appropriate concept, both from a sociological point of view, from a scientific point of view. I don't think it's anything that can be properly defined in any sensible way. So I'd be really happy to get rid of section 51(26) from the Constitution. Would you then need another provision to make laws with respect to Aboriginal and Torres Strait Islander peoples? I'm not sure that you would. I wrote something some time ago which looked at all the other powers in the Constitution that the Commonwealth has and thought that pretty much anything that you'd need to legislate specifically in relation to Indigenous matters could fall within those other powers. But I understand that there is that FOMO concern, fear of missing out, that by taking away that power you might lose the ability to do something that you haven't thought about in the future. But in any case, it's not for me to decide. It's not my proposal. I think we're going to have to leave that one for another day. The proposal that we're voting on is solely about the voice to Parliament, rather than about the race power in section 51(26), which under the current proposed amendment would just stay in place and stay the same. Okay, the final thing that people ask about, and they say it comes from different sort of perspectives, but it's this confusion between, on the one hand, people saying that the voice will be powerful and will be able to achieve things, and on the other hand saying, but hang on a minute, it can't actually legally compel the government to do anything. There's no legal obligation for consultation, etc., etc. So sometimes people say, well, hang on, who's telling the truth? Either it's powerful or it's not. Sometimes people say, well, there'd be no point in putting it in the Constitution if it couldn't compel the government to listen to it and respond. So it must be that there's some kind of secret agenda under it that does involve that kind of compulsion. And generally there's a deal of confusion about how those two things meet up. So let me try and explain. From the very beginning, when the voice was first proposed, the idea was to keep separate law and politics. And the idea was that the voice was not going to have there was going to be no legal obligation to consult it. There was going to be no legal requirement for the government to respond or Parliament to respond, or certainly no legal requirement to give effect to what the voice wants. How all this was supposed to work was on the political side, that there would be political pressure on the government to consult where consultation was needed, that there would be political pressure on the government to respond if the voice gives sensible advice. And it was the politics that's supposed to make it work, and it's the politics that makes it powerful. Now, if you think about it, there are a lot of powerful people or organisations in this country, and they're not necessarily powerful because they can compel the government or Parliament to do what they want. They're powerful for other reasons. They have influence because they have money, or because they have cultural influence, or because they have control of resources, or because they represent a large group of people. A whole lot of reasons that people can be powerful. Law is just a tiny role in the exercise of power. So the effectiveness of the voice is supposed to come through two means. The first is the voices of the Australian people. If the Australian people vote in a referendum to approve the existence of a voice, their voice will be saying to the government that we want things fixed, we want improvements, we want you to listen to what the voice is saying. We want you to make sensible laws and policies that are going to deal with the issues that clearly have not been adequately dealt with so far. So that's the first part of the political pressure. But the second, and the most important, will depend on what representations the voice makes. What's the quality of them? How good are they? Because what we want the voice to do is to get all that evidence from all those Indigenous communities all across the country and use that evidence to then make representations to the government explaining why this particular law has this adverse effect on these people. Here's the evidence that shows it. Here's a way of improving it so that we get rid of this adverse effect, but we still achieve the outcomes that we're trying to achieve, and we can do so in a way that, is better for everyone. How is it better for everyone? It might be because it's cheaper. You might be using less money if your funding is spent efficiently. It might be better for everyone to, improve Indigenous involvement in the economy, for example, improving productivity overall. So it's got to be the quality of the representations made by the voice which is going to have the impact. Because if you're a government or a parliament and you've been given very good, compelling evidence to show that an existing law or policy is not working in the best way, but here's a way to improve it, any sane government is going to do the improvement. And of course, it's all going to depend on whether that advice is good or bad. If the voice gives poor advice, or it gives advice that might help Indigenous people, but, bankrupt the economy or have really other bad effects on everybody else, well, of course, government's not going to take that advice. Why? Because of the other aspect of political influence, and that is that politicians are elected by the people in their electorate. Not the 3% of Indigenous people, but the people overall. And so politicians are very responsive to laws and to issues that are going to get them elected or get them to lose an election. So there is no interest in a government or a parliament adopting laws and policies, suggested by the voice or not, that are not going to be for the benefit overall of the Australian people. But there is an interest in adopting recommendations or representations, or at least taking that evidence and using it to develop their own policies if they can achieve better outcomes for the Australian people. So that's the answer. The voice can and should be powerful if it gives good, sensible advice to government that governments can take up and result in improved laws and policies that are good for everyone. So thanks for my viewers for raising those 3 questions. I hope I have managed to answer them adequately, and I look forward to seeing you next time with the Constitutional Clarion. Goodbye.